The Supreme Court practice and procedure has to be taken in two parts. One is the Supreme Court rules, where you are expected about the factual aspects of the Supreme Court rules. Another is the procedure. The procedure needs to be explained by way of different case laws that are available in the Supreme Court till now. Many leading judgments in various subjects. You have to have a sound understanding of those things. And the third is the concepts. You see, rules is 50 marks, and another 50 marks is procedure, that is combined with the case laws and the concepts on which the different jurisdictions of the Supreme Court are activated. Certain basic principles such as justice, equity and good conscience, such as ex debito justitiae, that is in the interest of justice, to secure the ends of justice, and the several aspects, sufficient cause, these are all aspects, miscarriage of justice, grave injustice, unconscionable orders that need to be struck down. These are all aspects on which the Supreme Court interferes with High Court judgments and interferes in a cause or matter. That the cause or matter is a very wide scope, is of very wide scope, and the cause or matter has not been given a fixed definition. Therefore, the Supreme Court can interfere in any cause or matter pending before any court. You see, this power is seen in 139A, but it can be read into 136 and 142 and even 32. See, these are all powers which the Supreme Court is keeping on reinventing. And another important power which the Supreme Court is reinventing is the review petition, where in the recent order, Justice R.F. Narman had held that the second review petition in case of death penalty cases is required. You see, in P. and Ishwar Iyer's case, the question of whether there is a need for a oral hearing was decided in criminal matters, and the Supreme Court held that it is enough if it is heard in chambers. Now, in the case of death penalty, if a second review petition is filed, then it needs to be entertained compulsorily as per the recent judgment of R.F. Nariman. It was a invention of the powers of the Supreme Court in so far as review jurisdiction is concerned. The power of the Supreme Court is to review its own judgments. The Supreme Court reviews its judgments as well as the judgments of the lower courts. It might be any court, but preferably the High Court in the extra appellate jurisdiction of the Supreme Court. You see, while the powers are largely undescribed, however, the powers are used in a particular manner, and the manner in which it is used is described by way of jurisdiction of Supreme Court. And what are the jurisdictions of Supreme Court? They are the transfer jurisdiction, writ jurisdiction, appellate jurisdiction, extra appellate jurisdiction, original jurisdiction, and in case of arbitration, the power to appoint arbitrator in international commercial arbitration disputes. Like this, these are all areas of jurisdiction. However, Supreme Court has a broad power also. So there is a mixing of the broad powers of Supreme Court with the exact jurisdictions that are provided as per the Constitution, and the style and the manner in which the broad powers which are undefined and the exact specified sections and powers by way of statute and by way of Constitution, these are all competing with each other depending on the situation of the case, and Supreme Court is keeping on reinventing. So this is how the jurisprudence of Supreme Court has developed in the recent times. And let us take for example 2 or 3 of the most latest judgments in Supreme Court practice and procedure that has really changed the way in which the Supreme Court practices. One is the Supreme Court's orders in the NJAC, National Judicial Appointment Commission. The central government got an act whereby Article 124(4), which provides that the Chief Justice of India shall be consulted before any judicial appointment is made. That was sought to be removed, and the opinion of the Chief Justice prior to any appointment is being made was tried to be done away with, and the Supreme Court came heavily on that, and the Supreme Court quashed the entire NJAC bill. This is an invention of the Supreme Court power. This is also an invention of the doctrine of separation of powers one another time by the Supreme Court. You see, and another is the Sahara judgment. The Sahara judgment of the Supreme Court. If you see, it is a judgment where the complaints of Supreme Court orders, whether it is mandatory, whether any explanation can be given by any authority so far as the complaints of Supreme Court orders is concerned, the Supreme Court very emphatically held that the orders are to be complied with. There cannot be any excuse by any government authority whatsoever in the manner in which the order is complied with. So once the Supreme Court specifies a particular direction or an order, it has to be complied with. In view of the power of the Supreme Court, Article 141, that is a law made by the Supreme Court, is final. It shall be obeyed by all authorities under Article 144. Therefore, this aspect was discussed in Sahara's case. And matter of complaints is no argument deal. That means once it is an order, it has to be complied with. And even though there is not specific statute providing any punishment for complying with the orders, the Supreme Court can keep the person under imprisonment for the very fact that he has not complied with the order. So this was another reinvention of the jurisdiction of Supreme Court. Like this, in every single area of jurisdiction, Supreme Court is constantly reinventing its jurisdiction. And that reinvention of jurisdiction is by way of concepts. And you have to explain the concepts that have developed and contributed to the reinvention of the powers of the Supreme Court. This is the procedure aspect. In case of the rules, what you have to do is detail the factual rules. You see, the 2013 has brought out amendment. It has increased the court fees from 250 to 1500 and from 50 to 500 in original jurisdiction in case of transparent writs, and from 250 to 1500 in case of SLPs. So this is one important aspect. The court fees has been increased. And you see, the advocate on record, the role of the advocate on record has come under the scanner, and name lending is prevented. That is one important rule. And the Supreme Court has also recently brought the certificate of practice rules. This might not be asked in the procedure aspect, practice and procedure. However, these are things that might be asked with respect to the role of the advocate on record, role of the advocate in a Supreme Court. So this is one thing.